Welcome back to the deep dive. Today, we're stepping into, well, a pretty complex world. Canonical law. That's the church's internal justice system.
Right, and we're looking at it through a really specific and honestly quite controversial case, the caso Gastalueta. Some people might know it as the Cuatrecasas-Martínez case.
Exactly. And our mission really is to kind of act as your guide. We're digging into a peer-reviewed academic paper that analyzes the canonical penal decree against Jose Maria Martinez Sanz, who was a lay member of Opus Dei.
In this paper, it pulls no punches. It basically argues that the whole canonical procedure wasn't really a genuine trial focused on justice under the law.
Not a real trial. What was it then, according to this analysis?
It suggests it was more like an ad hoc, sort of tailor-made disciplinary action. The driving force seems to have been responding to external pressure, media pressure mostly.
Like a PR move almost.
That's the implication.
Right.
And potentially at the cost of sidelining some really fundamental legal principles.
Okay, when you say fundamental principles, what are we talking about? Because that sounds serious.
Oh, it is. We're talking alleged violations of things you find in almost any modern legal system. Things like due process, the principle of legality, meaning the law must be clear beforehand, and non-retroactivity, not applying laws backwards.
Wow. So this really gets to some deep questions about papal authority, doesn't it? Like, how far does that power go if it bumps up against these basic rights?
Precisely. That's the core tension the paper explores. Invoking supreme power to, let's say, bend the rules always raises eyebrows. But to really get the critique, you need the timeline. It's messy.
Yeah, context is everything. Let's lay it out. So the person at the center is Jose Maria Martinez Sanz. He's a numerary in Opus Dei. That's a lay member committed to celibacy.
Right, and he was teaching at the Gastalueta School, which is connected to Opus Dei, between 2008 and 2010. Then accusations of sexual abuse involving a minor surfaced around 2011.
Okay, so what happened legally? First in the Spanish system, the secular courts.
Well, that was a roller coaster. Initially, between 2011 and 2012, the juvenile prosecution looked into it and actually shelved the case. They cited a lack of evidence against him.
So the state initially said, no case here.
Correct. But then, years later, things changed. In 2018, a provincial court in Vizcaya did sentence him to 11 years in prison for continuous sexual abuse. A huge turnaround.
11 years. That's significant. But wasn't there another twist?
There was. In 2020, it went up to the Spanish Supreme Court, and they drastically changed things again. They reduced the sentence from 11 years way down to just 2 years.
2 years. From 11. Why the reduction?
The Supreme Court found the severity was much less than initially judged. And crucially, in Spain, a 2-year sentence for a first-time offense often means no actual prison time is served.
So after all that, the secular outcome was no jail time.
Oh.
Okay. Now what about the church's side, the canonical process? Because you mentioned contradictions there too.
Even bigger ones, arguably. While all the Spanish court stuff was happening, the Vatican's own Congregation for the Doctrine of the Faith, the CDF, they handle major crimes like this, did its own investigation.
Okay, when was that?
Between 2014 and 2015. And their conclusion, issued October 9th, 2015, was crystal clear. They stated, and I quote, "The crimes have not been proven."
Not proven. So the Vatican's highest relevant office cleared him.
Cleared him. And they even recommended restoring his good name. Legally, within the church, that should have been it. Case closed.
But obviously wasn't. What happened?
No, it wasn't. Fast forward several years, there was a lot of media attention, a documentary, even a meeting between the victim's father and Pope Francis himself.
The pressure element again.
Seems so. Because in 2022, 7 years after the CDS finding, Pope Francis personally ordered a new canonical process to be started.
He overruled his own doctrinal office's finding from years earlier.
That's exactly what happened. And that decision, to reopen a closed case based seemingly on external factors, is really the trigger for the academic critique we're looking at.
Okay, so they restart the process. The paper calls this new procedure irregular. How did they even justify prosecuting this layman again, especially after the CDF had cleared him? What was the legal hook?
This is where, according to the source, the legal interpretation gets created, let's say. They had to use a specific law, Canon 1398, paragraph 2.
And what does that canon say?
It allows sanctions against a faithful who enjoys some dignity or performs an office or function in the church for abuse crimes involving a minor.
Okay, but the key phrase there is office or function in the church. Does being a lay religion teacher at a school automatically qualify? That seems like the crucial point.
It is the crucial point. And the paper argues forcefully that making it fit required what lawyers call an extensive interpretation. stretching the meaning.
Which is usually frowned upon in penal law, right? Don't you normally have to interpret criminal laws strictly?
Exactly. Canon 18 in church law says just that. Penal laws must be interpreted strictly. If there's doubt, you lean in favor of the accused. You can't broaden the definition just to catch someone. Favorabilia amplianda, odiosa restringenda, as the old saying goes. Favorable things should be expanded, hateful things restricted.
So they took this role, a religion teacher, which the paper notes is basically a job, even with a church mission, a missio canonica, and stretched it to fit the legal term office or function.
That's the argument. It's a stretch, because penal terms should be precise. And doing this, the author argues, creates a problem with equality.
How so?
Well, think about it. If some other layman, maybe one not employed by a Catholic school, did the same alleged act, would they fall under this specific canon? Probably not under a strict reading.
So it singles him out because of his job status in a church-related entity?
Essentially, yes, which kind of undermines that principle of strict interpretation and fairness. It starts to look like they're targeting him specifically, not just applying a general law.
Okay, that's one major issue, stretching the definition of who the law applies to. But you mentioned other problems. Something about time, non-retroactivity.
Yes, and this is maybe even more fundamental, according to the source. The alleged acts took place between 2008 and 2010.
Right.
But the version of Canon 1398 they used, the one that explicitly includes lay people like Martinez Sans as potential offenders under this specific section, that version only came into effect on December 8, 2021.
Wait a minute. So the law they prosecuted him under didn't actually exist in that form when the alleged events happened.
That's the core of the retroactivity argument. Canon 1313 is supposed to prevent this. It says if the law changes after a crime, you must apply the law that's most favorable to the accused.
And the law back in 2008-2010 regarding lay people in this context would have been much more favorable.
Or, arguably, wouldn't have applied this specific penalty framework to him as a layman at all. So, by using the 2021 law for acts from over a decade earlier, the process effectively ignored Canon 1313. It's a basic rule of law, generally. You can't be punished for breaking a rule that wasn't a rule yet.
So definition stretched, law applied backwards. What about the punishment itself? You mentioned the legality of punishment. Was there an issue there too?
Oh, yes. This is where the critique suggests things got really, really inventive and, frankly, quite strange from a legal standpoint.
How so? If they were applying Canon 1398, Section 2, what kind of punishment should have been available?
That canon points to specific types of sanctions listed in Canon 1336, Sections 2 to 4. These are called expiatory penalties, things like being forbidden certain acts or deprived of certain rights or powers. They're mostly designed with clergy in mind.
Okay, standard canonical penalties. But that's not what they imposed on Martinez Sans.
No. The decree didn't impose one of those Canon 1336 penalties. Instead, it imposed demission, basically, expulsion from Opus Dei itself.
Expulsion from Opus Dei. But where did they get the authority to impose that as a canonical penal sanction?
That's the million-dollar question. They didn't pull it from the Universal Code of Canon Law's penalty list. They pulled it directly from Opus Dei's own internal statutes, Article 30, Section 1, and Article 32, to be precise.
So they took a rule from a private membership handbook, essentially, and treated it as if it were a formal public criminal sentence under church law.
That's exactly the argument in the paper. It claims this move improperly transforms an internal disciplinary measure, kicking someone out of the club, basically into an official universal penal sanction.
Which would seem to violate that principle of legality of punishment, Canon 221, Section 3, which says you can only impose punishments that are actually defined in the relevant law.
Precisely. The punishment wasn't in the applicable penal law. It was an internal rule of the prelature. So the critique presents it as an invented punishment for a time-traveled crime applied via a stretched definition of the offender.
What's so crap?
Quite a construction.
It really sounds like the whole legal framework was being bypassed, which brings us back to that earlier point. How on earth did they justify doing all this?
Well, they invoke the ultimate authority, Canon 331. That's the canon defining the Pope's supreme, full, immediate, and universal power in the Church. The decree essentially argued, the Pope has supreme authority, therefore these deviations are permissible.
Because the Pope says so argument, but the paper questions that, right? Can that supreme power just override fundamental rights and legal principles whenever it seems convenient, even in sensitive cases?
The paper argues quite strongly, no. It suggests that even papal supremacy is understood to be bound by divine law and the fundamental rights of the faithful, which are part of the Church's divine constitution.
Meaning there are limits, even for the Pope.
Yes. The argument is that if full power means being unbound by any legal principle, then the papacy starts to look like an absolute monarchy, which isn't consistent with the Church's own understanding of its legal nature. Justice needs predictability, and you can't have that if you keep making exceptions based on supreme authority.
Okay, let's shift to the evidence. Because procedure is one thing, but how they handled the facts is also critical. Did the analysis find issues there? It sounds like they relied heavily on the Spanish court findings.
Yes, a strong reliance on the secular court's conviction, even though, as we discussed, that conviction was heavily mitigated later by the Spanish Supreme Court. This reliance itself raises questions about whether the canonical investigation was truly independent in reaching its own moral certainty.
But beyond just relying on external findings, was there specific evidence handling that seemed problematic?
Absolutely. According to the source, the delegate running this new process rejected 7 out of the 11 pieces of evidence the defense tried to submit.
7 out of 11. That's a lot. What was the most significant piece they rejected?
Probably the most crucial one. The report from the CDF's own 2015 investigation. The one that originally concluded the crimes weren't proven and cleared Martinez-Sanz.
They refused to admit the Vatican's own prior investigation that exonerated the guy. How did they justify that?
The justification given was, well, bizarre, according to the paper. The delegate claimed the defense had chosen not to rely on that CDF report during the separate secular court proceedings in Spain.
What does a tactical decision in a Spanish civil court have to do with the evidence admissible in an internal church canonical process? They're totally separate systems.
Exactly. The paper slams this as an improper mixing of juridical orders. A defense team might have strategic reasons for not using certain evidence in one venue, but that shouldn't stop the canonical judge from considering all relevant information, especially findings from their own institution, to reach their own independent conclusion. It suggests they weren't really trying to get to the bottom of it canonically.
It sounds like they were working backwards from a desired conclusion, maybe influenced by the Spanish outcome, rather than conducting a fresh, objective review. Did the paper find other signs of bias in how evidence was viewed?
Yes, a very telling example concerning witness testimony. The defense presented statements from 10 professors and 13 students. They all basically said they hadn't noticed any unusually long meetings between the professor and the student involved. Pretty straightforward factual testimony.
Just stating what they observed, or rather didn't observe. How did the delegate interpret that?
Instead of seeing it as neutral evidence or lack of corroborating evidence for the prosecution, the delegate interpreted it negatively. The delegate suggested this testimony showed an intention to want to deny any indication that could incriminate the professor.
Whoa. So the delegate basically accused potentially 23 witnesses of perjury or covering up without any proof, just because their testimony didn't fit the narrative.
That's the implication highlighted in the analysis. It suggests a presumption of guilt and a willingness to dismiss inconvenient evidence by questioning the motives of witnesses without basis. It's seen as a clear sign that objectivity in evaluating the evidence was compromised.
That really undermines the whole idea of a fair process. So if we circle back to the main point of the academic paper, it paints a picture of a legal process that was fundamentally flawed.
Deeply flawed, yes. Bypassing due process, misapplying laws, inventing punishments, questionable evidence handling. The analysis concludes this decree looks much more like a response driven by external factors media, perhaps papal intervention based on specific encounters, rather than a product of sound canonical justice.
And the danger here is the precedent it sets.
Exactly. It highlights this ongoing difficult tension in the Church's legal system.
Mhm.
You have the very real, very urgent need to act decisively against abuse, which everyone agrees on. But you also have the fundamental need to uphold basic legal principles, fairness, legality, and non-retroactivity, which protect everyone.
And if you sacrifice the principles for the sake of speed or appearances,
You risk the credibility and the moral authority of the entire justice system. The outcome might look decisive, but if the process wasn't just, is it truly justice?
it seems the immediate pressure to be seen to act might have overshadowed the duty to ensure the action was right according to its own laws.
And that brings us right back to invoking Canon 331, the Pope's supreme power. When that power is used, or perceived to be used, to effectively set aside core legal guarantees that are meant to protect all members of the Church, well, that leaves a huge challenge,
So the final thought isn't just about this one case, is it? It's bigger.
much bigger. The provocative question the paper leaves us with is this. How can the church ensure its exercise of justice is not only perceived as fair, but is truly just and respects fundamental rights, especially in these high-pressure, sensitive cases, without undermining the very legal foundations it relies on? Resolving that tension between pastoral urgency and juridical integrity is critical for the church's legal system going forward.
A profound challenge indeed. Thank you for guiding us through that complex legal and ethical maze. This has been the deep dive.